Since the collapse of the Surfside Towers, there have been a lot of legal changes that have upset a lot of members of condominium associations. And you should know what some of these changes are because they will affect you. Hi, I'm Jane Muir, and I'm a condo lawyer and business lawyer in Miami. After the Surfside Towers collapsed, the legislature investigated what led up to that collapse. And what had happened in that building was that the members of the board had noticed that there were structural defects in the building, and they wanted to make repairs to those structural defects. But their budget was limited, and the members of this association objected every time they wanted to collect money to pay for structural repairs, which resulted in the repairs never being completed. Ultimately, there was a combination of failures, one being the failure to repair these structural defects, and then there had been warning system, an alarm system installed that the security staff did not know how to use to inform everyone in the building that there was something that was happening that they needed to evacuate. So even though there was warning at the front desk that there was some shifting happening in the building and that everybody needed to get out, they could not use the system that was necessary to inform everybody to get out in the middle of the night. And that's why the disaster occurred. So what the legislature did in order to try and avoid this happening in the future was they mandated reserve funds specific to the structure of a building in order to make sure that an association wouldn't have to assess and collect in advance of making these kinds of repairs. So under the prior structure of the law, an association would realize that they needed to make structural repairs. They would ask all the unit owners to participate in an assessment. The unit owners would have to contribute financially towards that assessment, and then the association could spend money. Now, what has been added to this system is that all of the unit owners have to maintain a structural reserve at all times, so that if there appears a structural damage that needs repair, they already have the money there to spend. And this is kind of a good idea, because if you have to collect the money, then you're going to have a group of people who disagree with making the assessment, and maybe they just won't pay, which means you have to go through the process of collection, which is a letter, wait 30 days, another letter, wait 30 more days, a lien, wait 45 days, foreclose on the property, go through the court system, months and months pass, and then you can get the money from the person or sell their unit to get the money. But that process takes potentially a year or longer. And meanwhile, there's a structural defect that the association can't fix because they don't have the money because they're busy collecting the money. So number one change was these reserves were mandated for structural repairs. Another change that was mandated was every building is expected to do what's called a SIRS study, SIRS, and the study is designed to evaluate the condition of a building and inform the members of the association of that condition so that nobody is surprised if there are structural defects in a building. And that's a really good idea too, because it's important to have your property evaluated to make sure that it's in good repair, or else you could have another Surfside crisis. There are other changes that have been in process, and there have been a lot of objections to the changes that occurred after Surfside from people who feel that they're too expensive or burdensome or difficult to comply with. And if you're a leader in an association and you'd like to know what compliance steps you need to take, then we hope that you'll consider us and set up a consultation so that we can review the status of your association, how old it is, and what compliance measures are required to comply with the new laws.